All right. Good morning. This is Attorney Vince Davis, and these are my office hours. This morning, I'd like to talk to you about a couple of issues. And I keep seeing these issues over and over again, or I keep talking to people over and over again. The first issue is something that happened to me yesterday. I was talking to a person, I think the person was in Northern California. I'm in the Los Angeles area, and the conversation started off with me texting with the person. Person needed some help regarding their CPS case. What I didn't know at the time was this person was at the end of the case. In a couple of months, they're going to have the hearing on whether they should terminate his parental rights or not. So basically, he was in what I call module 6 of his case. And he and I finally got to talk on the telephone. And the first maybe 45 minutes of the telephone call was about how he got screwed at the beginning of the case. And I listened to the story, and it did sound like, he got the short end of the stick and was treated unfairly at the beginning of the case. However, as I explained to him, all of that stuff that happened to him at the beginning of the case, unfortunately, was not relevant to his case at the end of the case in Module 6. And the reason is because there was a trial. There were actually two trials at the beginning of the case. There was a 6-month hearing and a trial that he had, and a 12-month hearing and a trial that he had. He had lost all of those trials, and he did not appeal any of them. And if he had won those appeals, his story may become relevant. His story may be relevant if he ever decides to sue CPS and the county in California for violating his civil rights. But in terms of stopping the termination of parental rights, what happened to him at the beginning of the case is not necessarily important. So this is just a word to the wise. When you're talking to an attorney about your case, I want you to make sure that you focus on what's happening in your case right now. So if you're about facing the termination of your parental rights, don't call up the attorney and start talking to him or her about what happened, a year ago in your case, because it's just not relevant. Each module in your case focuses on different legal tests and different evidentiary burdens. So the evidentiary burden and the legal tests at the end of your case are not the same as the legal test and the evidentiary burdens at the beginning of your case. Hence, the story about how he lost his child, although somewhat interesting, doesn't have anything to do with the end of his case. And if you're trying to get someone to help you, you may not want to, talk about that with that person and waste the time that you have with that attorney, telling that attorney about something that's bothering you, but is not important to that attorney representing you at the time. And that kind of segues into my next issue. One of the things that is important for him to win his case and to stop the termination of the parental rights, one of the best defenses, and this came up in a couple conversations this week, is the bonding study. And I think this might be relevant to cases all across the country, but particularly in California. One of the best defenses in stopping the termination of your parental rights is a bonding study that comes back and says, um, you know, it would be detrimental to the child, not to the parent, but detrimental to the child for the parental rights to be terminated. And of course, the person doing the bonding study has to weigh the detriment of terminating the parental rights versus not terminating the parental rights. In other words, would adoption with the foster parents outweigh the benefits of keeping the relationship between parent and child? Sometimes children have a bond between the parent and child that's so close that you don't want to upset that bond or tear that bond completely away. You know, um, and the reason why it's important is you want to make that motion for a bonding study early on. So, for example, when you terminate or the court terminates your family reunification services in California, they set the hearing to terminate your parental rights 120 days out. And I think it's very similar in other states. Well, at that hearing or soon thereafter, you want to make your motion for a bonding study. And here's why. Because during that intervening period, what happens inevitably is that the states and the counties want to limit your visitation. And the reason why they want to limit your visitation is because they don't want you to be able to argue at the termination of rights hearing that you have a bond with the child such that termination would not be best for the child. And the best way for them to do that is to stop your visitation or to limit your visitation. So one day you go to court and you have visits twice, two, 3 times a week, and all of a sudden you lose your family reunification services. And within a week or two, you get a telephone call or an email, and now you only have visits once every other week. Or I just heard of a case where the guy went from 2 or 3 times a week to 1 time per month. Well, the reason why they did that was in part to limit his visitation so that in that 120-day period, the bond between him and his daughter starts to decrease. And therefore, when he gets to the termination hearing of his rights, he can't argue or he can't prove that he has a relation such that termination of his rights would be detrimental to the child. Not detrimental to him, but detrimental to the child. So keep that in mind. And the best time to do that is right after your rights, not your rights, but your family reunification services have been terminated. If you wait to do it a month or two before the termination of rights hearing, your visitation has already been limited. The relationship between you and your child and the bond between you and your child has already been limited. And, you're not going to have a strong finding of a bond when the psychologist goes to do the bonding study. I hope that makes sense. If any of you have any further questions, please let me know. All right. The next thing that I want to talk about this morning is an article. It's from a couple of years ago, but I read it. I read it, and a colleague and I were talking about it this weekend. It's from the ACLU, and it was written by a woman a couple of years ago, and the woman's name was Haina Navid, and she works in New York, I believe, and she started off being a nurse. And then she went back to law school. And then after law school, she worked for the ACLU, thinking that she would do good in helping with the human rights of people. And she started getting involved with the child welfare system there in New York, specifically CPS in New York. And in those experiences, she came to this conclusion, a conclusion that I came to decades ago, is that sometimes the system tends to punish people who are poor. There is in my mind, a direct correlation between poverty and people involved in the CPS system. Los Angeles County is one of the biggest CPS systems in the country. I mean, they have a whole building, what is it, 5 floors devoted to, taking children away or quote unquote protecting children, however you want to look at it, and many, many courtrooms. And it got so big that they had to open up a second courtroom in another part of the county, another courthouse in another part of the county where they have 2 or 3 more courtrooms. So there's a lot of cases. Some people call it a big business, a cottage industry. And when you go into the courthouse, sometimes you go on either floor and you see all the people there in the waiting areas. you see people of a certain economic class, and it tends to be Black and brown people, not 100% and not 100% poor people, but it's the majority of people. Many, many, many years ago, an attorney who kind of trained me in child welfare law and CPS law wanted to bring a lawsuit about the unequal enforcement of child welfare laws or CPS laws. It was his contention at the time that CPS laws were discriminatorily enforced, meaning there were too many Black and brown people in the courthouses, and he didn't see other, um, races being in the courthouse as compared to Black and brown people. But one of the things that I think he was wrong about, it wasn't really a race thing more than it was an economic thing. I've come to the conclusion over these years that, maybe race does have a little bit to do with it, but I think it's really more of an economic thing. If you have the economic resources, um, you're able to skirt by or stay out of the child welfare system. If you don't, they're more likely to file a case on you. Let me give you an example. Many years ago, there was a case. I can't mention any names, but it was someone famous. And I've seen this a couple of times where they had money, they were famous, and, CPS was involved in investigating the case. And CPS ended up not filing a case on these different families. And I came to the conclusion because some of the families were of minority descent, but they didn't file it mainly because these people had the resources, quote unquote, to eliminate the risks to the children. But those same types of cases, if the people didn't have the resources, they were filed on and cases were started and then the children were removed and, on goes the system and, maybe they've lost their children. So it's not so much a racial discrimination as it is an economic discrimination. And that's what the article in the ACLU was about. So if you go to aclu.org and you search Hina, Hina, Naveed, Naveed, you'll find her article. And it says her article is entitled "The Child Welfare System Needs an Overhaul." And it needs an overhaul, and I totally agree with that. Um, I don't have solutions, though. I don't have the answer, the magic bullet. I think it's something that needs to be studied. I think it's something that needs to be serious thought needs to be given to it. I do have two possible solutions to it. I don't know if it would solve the problem. Number one, I think social workers should be mandated to wear body cameras, you know, when they do interviews. I can't tell you how many times, thousands and thousands of times, people tell me, "Mr. Davis, I didn't say that to the social worker. She wrote it down wrong." I'm going to give you an example. I did a case up north one time where this child was interviewed at the age of about 10 years old, and the child allegedly said ABC. My client, who was within earshot of the interview, a parent, said, "The kid didn't say that. The kid didn't say ABC. She said CDE." Close, but not exactly. And the judge believed the social worker when we went to trial. And at the time, I wasn't allowed to call this child as a witness to cross-examine. At the time, the judge found that it would be detrimental to the child to be called as a witness. There has been law since then that kind of changes that. But anyway, we lost the trial. And the child ended up in guardianship with grandparents who were friendly to the parents. They ended up moving to another state, and the parents followed. And years later, when that child became an adult and the guardianship was over, because I kept in contact with my client, the parents, during holidays, Christmas, Thanksgiving, that type of thing. Um, I talked to the child who is now an adult, and the child told me, Mr. Davis, I didn't say what the social worker said I said. And I said, what the social worker said? I said ABC, and that's not what I said. I did say CDE, and I was misquoted by the social worker. Now, I always, in my mind, was that a misquote or was that an intentional lie? I don't know what else to call it. Was it an intentional lie to mislead the court in order to win the case? Because without that testimony, the social worker would have lost the trial and I would have won. But the social worker won, which started, domino effect, and we lose, and the kids go into a permanent plan of legal guardianship with the grandparents. And if you wear a body cam, you don't have those arguments. Now, many years ago, wearing a body cam and tape recording and videotaping, it was very expensive, but it's not now. You know, Police wear body cams all the time, and they're inexpensive, and it would stop a lot of this he said, she said type of thing. Why don't we require social workers to wear body cams during interviews with parents and children? It would solve a lot of problems. That's my first solution. My second solution is, there are a few states, not a lot, but a few states allow parents to have jury trials. In California, we don't allow jury trials in juvenile dependency cases and CPS cases. They were decided by judges, just a jury of one. I think a lot of problems would be solved if you had even a modified jury of 6 people. But if you had people from the community, your peers, judging you about whether something was child abuse, whether you were a risk or a danger to a child, I think we'd have a lot of different outcomes. Sometimes judges, I'm sure they try to do their best, but sometimes they're far removed from what's happening in out there in the communities. And, they do these cases day in and day out. There may be pressures to protect children, and they have to make the ultimate decisions. I've seen some judges, excuse me, over the years make decisions that turned out to be wrong, and they caught hell for it. And, some careers ruined. And, maybe that's in the back of the mind. And maybe sometimes judges are too conservative. Maybe they're trying to do their best. But if a jury decides, that takes it away from the judge, and the jury is responsible for making the decisions about whether a child should be returned to the parent, or whether the parent is a risk to the child, or whether the parent is a danger to the child. So I think the body cam and I think the jury trial would be a good start in alleviating the biases and overhauling the system that we have currently in our child welfare system. Right now, we have a system that I think is unfair in many ways. And I can't tell you all of the ways that I think it's unfair. It's too much for one show. I think in a lot of cases, people are doing the best that they can. I think in a lot of ways, people aren't doing the best that they can. It's hard to decipher and it's hard to tell when this is happening. But the only people that are really suffering are the children and, of course, the parents. And I think something needs to be done with respect to this. If you have any questions and you're watching right now, go ahead and post them in the comments and I'll take a couple questions. There is one question I see. from Facebook about the bonding study. What is a bonding study? So in California and in maybe some other states, you can't terminate parental rights if the parent proves that it's detrimental to the child, not detrimental to the parent, that it's detrimental to the child to terminate that parent-child relationship. Do I ever see cases like that? Yes, I do. Do I ever see cases where it's not detrimental? Yes, I do. So what you need is you need some expert testimony to come in and, tell the judge, oh, if you terminate the parental rights in this particular case, it would be detrimental to the child, and therefore we shouldn't terminate the parental rights. What happens in a bonding study is you send the child to the psychologist. Psychologist interviews the child, sometimes and interviews the parent and interviews them together, does an evaluation. Sometimes the psychologist also interviews the foster parent and the child together to see, to kind of balance, you know, the benefit and the burden of terminating versus not terminating. And if you get a good bonding study and a good expert who comes to court and testifies, you can stop the termination of the parental rights. I can only think of one occasion, there may have been more, but I can only think of one occasion that sticks in my mind where I had a bonding study and the bonding study came back. Yes, it would be detrimental to terminate the parental rights, and the judge didn't go with it. The judge didn't find the bonding expert credible, um, which is still, kind of gnaws at me. And I appealed that case, and I lost. Court of Appeals said that the judge had enough facts in front of him to still rule that it wouldn't be detrimental to the child to terminate their parental rights. This case was in Orange County, and it was a very close case, and I think the judge gave it a lot of thought. It was kind of a ugly case. There were a lot of bad facts in that case against the parents, and I think that contributed to the trial judge's decision and contributed to the Court of Appeals upholding that decision. But, you know, um, that just goes to show you that it doesn't always work. But, if you're a parent facing that particular problem, you got to get that bonding study done. All right. I'm looking at the questions now. I don't see any questions. So that will be it for today's office hours. Remember, I'm going to be trying to do these shows every day at 6:30 a.m. for approximately 30 minutes. If you have questions for tomorrow, develop them and come tomorrow with your questions. Otherwise, I'll see everyone tomorrow at 6:30, and everyone have a good day. Bye-bye.